Miranda v. Arizona stands as one of our nation's landmark court cases which resulted in a 5-4 decision of the United States Supreme Court. The case was argued February 28 through March 1, 1966, and was decided on June 13, 1966. The court ruled that persons suspected of a criminal act must be informed of their right to counsel with an attorney and of their right against self-incrimination prior to questioning by police.
Hello, little girl. Do you need a lift?
Thank you for stopping, mister. 10 cars passed by before you stopped.
Oh, I'm just doing what I hope someone else would do for me. Where are you headed?
Anywhere but here, mister. You see, I ran away a week ago and my parents have the police after me.
Well, let's see what we can do for you. Being out on your own so long must be pretty hard to find food, huh?
A little bit now that you mention it, but I don't want to trouble you more than I already have.
Oh, it's no problem at all. In fact, I'm just coming back from the market. I hope you like fruit.
Well, actually, mister, that's really nice of you, but I'm not all that hungry.
Why the sudden change of heart? You just said you were hungry a second ago. You can't accept food from the stranger who just picked you up?
No, mister, it's not that. It's just that
Do you not like fruit or something? Do you wish it were candy? You know what? You kids today eat too much candy. When you're older, you're gonna be wishing you ate some more fruit.
No, mister. I love fruit. It's just that it's too ripe. That's all.
Too ripe? I bought it fresh today. It's delicious. Try it.
I think I need to get out, mister. Please open the door.
Not until you try my fruit. Take a bite.
Mister, please don't do this. It's too ripe. I can't.
Oh, you'll eat it, and you'll like it.
Mister, please, no.
In 1963, Ernesto Arturo Miranda of Phoenix, Arizona, was arrested for his taking part. Later, he confessed to robbery and attempted rape after hours of police interrogation. At his trial, prosecutors offered his confession as their only evidence. Ernest was convicted of rape and kidnapping and sentenced to 20 to 30 years in prison on each charge. Alvin Moore, Ernest's defense lawyer, appealed to the Arizona Supreme Court and contested that Ernest's confession should not have been allowed to be used in the trial because he did not know of his Fifth Amendment right against self-incrimination or his Sixth Amendment right, which would grant him the assistance of an attorney. The Arizona Supreme Court denied the request and upheld the conviction, emphasized heavily on the fact that Miranda did not specifically request counsel. The question now becomes, do police have an obligation to inform the convicted felon of their Fifth and Sixth Amendment rights? If yes, at what point in this process do they have to be informed? The decision was to be made by Supreme Court Chief Justice Earl Warren and his 6 supporting court justices. Ladies and gentlemen, welcome to tonight's main event. It is not a decision of right or wrong, but what is right to those who have done the wrong. Entering first, weighing in at 185 pounds. 3 years ago, he was arrested and convicted for rape and robbery on his own confession. Tonight, he comes to the court looking to overturn this decision, for when he was arrested, he was uninformed of his rights to an attorney and against self-incrimination. The defendant, Ernesto Arturo Miranda. Entering next, weighing in at a population of over 5 million. Stating that a man who's been convicted before should be well aware of his rights, and since he confessed to doing the awful crimes he was charged with, deserves to serve the time he was sentenced to. The plaintiff, the state of Arizona. Ladies and gentlemen, and millions watching around the world, are you ready? Then let's get ready to rumble.